about if the parent or guardian, as in so many of these cases, they're undocumented. What are the implications of that? Do they ever get reported?
Sure, great question. So just for the tape, the question was, if the parent is undocumented, what are the repercussions for them coming forward, taking sponsorship of the child from the release, or coming into the immigration court building, or going to a family court building? Well, here in New York, the family courts are pretty well trained. There is occasional anomalies that they understand an undocumented person can still serve in a family law capacity as custodian or guardian. Immigration status is taken into consideration when there's contested custody. So if mom and dad are going against each other and one of the people is undocumented, the judge will consider it as a totality of factors, but it's never determinative. But you don't have to have an undocumented relative be afraid of going into family court that they're going to call the police or call immigration to come and arrest them. Same with the federal immigration building. I was very concerned when I began this work, and I interviewed the chief of ICE, the Immigration Customs Enforcement lawyers, and I also interviewed the judges, and I said, I want to know if the parents are coming into the room, are you going to arrest them? And Judge Rowan told me in 20 years of being on the bench, there's been only one incident where someone was arrested coming into a courtroom as a witness, and that person was dangerous, became physically violent with the court. But the majority of the family members are quite brave. They're told to bring the children to court. They're told they need to go to family court, and they do it. Now, there are no benefits for family members when the child gets special immigrant juvenile status. What Congress gives to the children, it doesn't give derivative benefits to the parents. So that child, even though the child will get status and later become a citizen, that child will never be able to sponsor mom or dad. On the other hand, this is not an area of high priority enforcement. So Claire mentioned prosecutorial discretion. We really need to work with that slide. Prosecutorial discretion for adults is also possible. So the 30 limit had to do more with the childhood protected status that President Obama did. When a family's lived here a long time, even when they don't have status, if their children have status, either because they acquired status or they're born here or they've acquired status some other way, but the parents can't access legal status, that's often a case for prosecutorial discretion. We have approximately 12 million undocumented people in the country. The priority of the national enforcement, and President Obama has deported 2.3 million people, so don't think he's the bleeding heart administration. But the priority is national security and people with criminal convictions. So disrupting a family and breaking them apart is unlikely to be a high priority. Occasionally, though, when we interview the child, we start interviewing the family, and I can tell you another law firm helped the child first, then they interviewed the mother, and they found she had been systematically, domestically abused, violent abuse, and they were able to secure asylum for her. And that was 10 years after she entered the country. Normally for an adult, there's a 1-year deadline to apply for asylum, but in her situation, things had changed because our federal government had deported her husband back to El Salvador, and he was now making threats against her parents, driving by their house with guns, shooting at the house, threatening her sisters and brothers, saying, I'm going to get my wife back, I'm going to get my kids back. And that new situation, she applied affirmatively for asylum, taking the risk she'd be put in deportation proceedings. She won asylum. So sometimes we ask you to take on the work of a child, and you're going to end up taking on a family, but the remedies are not as simple for adults. None of it's simple, but they're not as readily available. That was one question. Another question. Yes, blue shirt. Yes.
Yes. So in terms of special immigrant juvenile status, at family court or guardianship stage,
yes,
and for a case where there's abandoned by one parent, are there still service requirements
yes,
on the abandoned parent?
yes.
So if there's no last time hours, let's say,
right,
are there procedures in that case?
So in our advanced training Thursday, where we're going to go through advanced discussion of special immigrant juvenile status, we're going to spend quite a bit of time on service of process. When you're in family court, just like in any civil matter, you have the rules of the CPLR, the civil procedure rules, right, that require notice to parties. And these are adversarial hearings in a sense. But the family court is used to abandonment. I mean, it's sad to say, but too many parents do abandon. And so the type of service that required may be last known address, may be delivery to the grandparents' home, who then confirm the information was delivered orally or in writing. I've even seen service accepted in federal court by Facebook. So I think the family court judges are sensitive to the fact that you're going to send to their last known address. Rarely is hiring a process server or publication required. That said, there are a few family court judges, every judge has his or her prerogatives, who think you should advertise in the local general newspaper circulation in El Salvador, Guatemala. So what we often try to do working with you is evaluate the context of your case. And if you know where the uncle is, and the uncle knows where the mom is who abandoned the child, and we can get the uncle to agree to deliver the papers and get the mother to sign for them, we might even get a consent to an appointment of a guardian. And then the family court judge is less concerned. I have seen judges in Westchester County, for example, appoint lawyers for parents living in Guatemala and El Salvador. So the appointed counsel communicates by phone with the parents there who say, we can't take care of this child, we sent him to the uncle, we really don't want him back, he's on his own now, he's 15, he's old enough. They say it in a very matter-of-fact way. It could be, it's a different culture than what we have in the United States. It could be the situation of the family. So really your family judge is going to differ, service of process is required. Now some of you may be familiar with the Hague Convention on Service in international custody disputes. That requires you to do much more process where you have to go through the U.S. consulate and do service very formally. They're the only country who's a treaty member of that treaty in these international custody disputes is Mexico. We rarely have a Mexican case, and you can understand why, because the kids we see are those who were released into the United States. The Mexican kids have been pushed back. Even if it was a Hague country case with service, we can work on alternative forms of service. Okay, that was a really good question. Yes, sir.
Just a quick question about Judge Rowan. Is she an administrative
Yes.
judge, or is she a regular federal?
No immigration judge is a regular Article III federal judge. They're also not an Article I judge like you might be used to with a magistrate or a bankruptcy judge, right? They're not even like the Veterans Court of Benefit Affairs, nor are they like a Social Security judge, which is an ALJ. ALJs have to take a test and be appointed under the federal system. Immigration judges are employees of the Department of Justice. They are exempt civil service employees. So they have been vetted and selected by the Department of Justice. The Department of Justice used to hold all of immigration, but since 2002 we have Department of Homeland Security. So the prosecutor in Judge Rowan's courtroom, it's an administrative hearing, is a prosecutor from DHS appealing to a hearing officer from DOJ. They don't have life tenure, they don't have even a term of years, but it's fairly rare for an immigration judge to be removed, except for pretty gross incompetence or malfeasance. The government attorneys are not quite the same as Department of Justice U.S. attorneys. I mean, they are very professional. They have professional support. There are more than 800 prosecutors working for ICE within the United States. And here in New York, this is one of the largest immigration courts in the country. There are 28 judges. They have very few resources. They have about 6 law clerks to be shared amongst the 28 judges. And so, you know, if your case was going to involve a lot of practice before the immigration court, we're doing a special training on the 29th about immigration court procedure, but the majority of these cases, it's really you make one appearance, you tell the judge I need a continuance because I'm going to the asylum office, or I'm going to the family court, or I'm doing both. The judge gives a very generous continuance. As soon as you find some process movement in those cases in the positive regard, and so far we've only lost one case and we won it on appeal, so stick with us, win-win. The judge is quite happy to give a 6-month, 9-month continuance. Lately, the trial attorneys are pushing back a little bit. We think that's political pressure. The Obama administration wants to say they're on top of these cases, but Judge Rowan is well educated about the delays in family court and the delays in the asylum office. So Patricia Rowan is really, she's terrific. Patricia A. Rowan. There are other cases before other judges. The other judges know the day of the month we're at the immigration court, and frankly, they're sending children to us. And Judge Rowan, being generous, is willing to take on the extra work that's not even her responsibility if we will accept the representation of the child. Okay, let me go to this side of the room. Yes.
Two yes or no questions. First, is there a cap for SIDG annually? And also, is past membership anything a ground of inadmissibility for adjustment status?
Great. So you know some immigration law. Very good. Okay, so people should know that in immigration law, normally in our legal immigration system, we have quota caps. We don't have them for immediate relatives like spouses of U.S. citizens. I know yes or no. You asked me. Yes, they're fourth preference immigrants. But if you look at the visa bulletin, you'll see fourth preference has never reached its cap. And last year, I looked at the number of total SIDG applications that were approved across the whole country, and there were less than 3,000. I figure I'm going to be doing 10% of those like any minute now, just from the volume of our work. The other thing you asked me was, if you are a former gang member, how does that impact your case? It could be a bar to adjustment of status because you could be seen as a persecutor of others, so it's going to need to be contextualized. What did you do with the gang? Was it a duress context? How involved were you? It is potentially possible to get a waiver for someone who qualifies for special immigrant juvenile. More frequently, it becomes a bar in an asylum claim because there's a statutory bar for the persecutors of others. And the Supreme Court a few years ago did not create a duress exception or verify one, and the BIA has never ruled on remand. So it is, if your young person admits to you that they were indeed part of a gang, you're definitely going to want to consult with us about what the repercussions are. I met an 11-year-old who joined a gang here, and he said, in Brooklyn, you join the gang or you're not safe to go to school. And we were trying to counsel, he's in foster care, we're trying to counsel him to that's not the right way to go. And we talked with the social workers about could he find a better or safe replacement. But he was quite proud of being in his gang, but he's also speaking through the lens of an 11-year-old. So what does he do in the gang as an 11-year-old? He plays basketball. I mean, basically, that's all he admitted, but he was pretty proud of being one of the cool guys. So we have to contextualize it. I have seen people qualify for immigration relief who were even older and who were escaping before they participated in direct violence themselves, who have been successful in winning asylum. More questions? Yes? Yes, sure. Well, you notice we didn't give you those, right? Okay, so typically when we're at court once a month, and it takes us about 2 weeks to write up that placement memo. And to be really honest, it'd be great if I could immediately place that case, but most of the case placement is done by me calling you. So I can only do so many a week, and so we're probably not placing that case right away. So when we're asking you to take a case, it's probably one that's coming back up after the first continuance. So a typical number of continuances in immigration court is 2 to 4. The judge is actually telling us that we have fewer continuances on her docket than any other docket in the court because we are efficient. But the child's probably been in the United States over a year by the time you're going to get the case. 6 months before they went to their first immigration hearing, maybe 4 to 6 months till we're ready to place it with you. Then you're going to meet that child. Let's say you decide this is a custody case. We haven't talked much about custody, so let's do a custody case. Mom is here in the United States working. Dad abandoned the child when he was very young. Very young. In fact, the minute the baby was born, he's out of the picture. This is not an atypical story. The Second Appellate Department has affirmed in a series of recent cases that even abandonment at that birth, that very young age, qualifies as abandonment for special immigrant juvenile findings. So mom is going to go into family court making a custody petition, and if she's doing it in the Bronx or in Brooklyn, it will probably be done within less than 4 months. But if you're doing it in Nassau or Suffolk, it could take much longer just because of the workloads of those courts. Manhattan, also very quick, but we don't see as many children who live in Manhattan, just the expense of the city. A lot of kids in Queens, in the Bronx, Westchester, but about 25 to 30% of all the children are Long Island. So the first appearance you're going to make in immigration court, you're going to say, Your Honor, I'm agreed to represent this child pro bono. I'm here with Safe Passage Project. I'm asking you for a 6-month continuance. Because I've just met the child, I'm going to be pursuing a custody remedy in family court. And the judge is going to grant that continuance. Then the family court process is going to be fast or slow, depending on the workload of the family court and the service question that I was asked earlier. If the judge insists on you doing everything possible to find and locate that abandoning father, that can take longer. But in most situations, you file your custody petition, the judge issues the summons, you then come back on a date that they set to show that you have provided the service. And in some of the family courts, they will do the special immigrant juvenile motion that day on the first return, and in others, they're going to set another date. So it's 4 months to 6 months in family court, maybe 8 months is ideal. I have to say, the delays usually are the attorney's delays. I mean, it's not the courts. It's like just not convenient for you. You don't get it filed. Then you get the special immigrant juvenile findings order from the family court, and you file the petition form we talked about with immigration, I-360. That, upon the filing, all you need is the receipt for that. That can make the motion to terminate the immigration proceedings. So whew, that's done. No more going back to immigration court. Now we're just waiting for immigration to adjudicate that petition. The statute says 6 months. They have 6 months to adjudicate the petition. They've been falling behind, but we know how to nudge them. The typical case is 3 to 8 months of that petition being adjudicated. And then that last stage, the adjustment of status, it's, again, usually done within 6 months of the time of the filing. Again, I find most of the delays are the attorney's delays, just not getting to the work on your desk. Sometimes it's securing a record, you know, like the child has a partial birth certificate or doesn't have the official birth certificate, you may take some weeks to get that. So if you commit to a case, what is it taking you in terms of total time? Well, the fastest I've seen is 4 months, start to finish, super fast. That was an asylum case. The asylum office does right now adjudicate these quickly. A few years ago, they were putting them into like 1 and 2 year waiting queues. The slowest case, I would say, is when we still have pending asylum case that's been pending for 2 years, and that's because it got caught up in the backlogs. The typical case, I would say it's going to be with you for about a year. And then if you're asking me, like, how many hours might you commit, I really think that depends on you and the child. I would like to say you really shouldn't be filing an asylum case unless you've done about 20 hours of interviewing and research and writing, because I don't see how you can be prepared in really less than that. You should take several meetings, just build trust and get the details and the narrative and practice. We will help you practice for the interview. And I would say in the guardianship or the family court stage, it can be actually a lot less because it's all standard forms and we have sample pleadings to share with you. So I don't think you should be afraid that you're going to go into a field where you have to invent new pleadings or you have to write new legal briefs. Davey just handed me a very robust memorandum she, Gonzalo, and Carlos worked on, which gathered all of the cases in New York on abuse, neglect, and abandonment. So we turned that into a handy-dandy research tool for our attorneys. But you know, to be fair, I think you're making at least a 20-hour commitment and more like a 100-hour commitment, probably. Okay, another question. Yes?
There was a person, a youngster received his adjustment status through the Obama program. Is he ever able to petition for his parents or any other family?
So the DACA, the Deferred Action for Childhood Arrivals, they're actually not getting an adjustment of status, they're just getting a work permit. So they stop accruing unlawful presence. They're getting what is called lawful status, but it's not permanent residence. And they get a work permit, and they can then get that renewed every 2 years. It doesn't convert to a green card. So they can't sponsor a spouse, a parent, a child through that. So sometimes we meet young people who have DACA, but who are eligible for SIDGE. And we say, well, it's nice that you have DACA, but your mom or dad abandoned you or abused you, and you should really be going for SIDGE.
So if they don't have, they're not in this type of situation, they can't.
They have to have a situation where they've been abandoned, neglected, or abused by one parent. I just want to caution attorneys. I mean, immigration attorneys often try to be very creative, like tax attorneys, like trust and estates attorneys. The family court does not want to see a situation where it's a manufactured separation. And they can order a home investigation. So just like a false marriage, you don't want to have a false bad family, right? And I also want to caution you that some of the family court judges have been concerned about smugglers sponsoring children for SIDGE. These are particularly children from South Asia. but they're worried, who is this person coming in to be the child's guardian, especially when it's not a relative. And so there is an investigation of the guardian in the household, because we don't want to make the child's situation worse. Yes?
In line with that question, I mean, in our community, which is the Sikh community from Virginia,
Yes.
I'm running into cases where these kids, are struggling to find a guardian, and then they are finding someone from within the community. And from my brief experience, it seems that they are giving fees upwards around $20,000 to find someone.
So they're paying someone to be their guardian.
They are working with their gas stations.
Oh, that's so horrible.
Unfortunately, the recommendations for these guardians are coming from within the religious centers. And so what are the options available to these kids? Because they don't want to go, I mean, they're coming from rural areas and they're
Right.
afraid of the school system. They don't want to be put in foster care. Something as simple as, just food choices, or they want the comfort of their community and the culture.
Yes, I understand. Plus culturally, there is a tradition in many parts of the world where you basically apprentice yourself. So you know that to make your way in the world, you're going to go live with an adopted uncle and work in that household as your path to work or education. Right. Right. So my position with the family court has been, don't punish the child if you believe the child is being trafficked. Then give the child a U visa. Because if that child is working and all that money is going to, quote, the sponsor, that is actually a labor law violation. And of course that could create some tension, where you're arguing that, but it may be in the family court you could try for, you don't want that person to be the guardian if they're being paid. So what are the options? There's no simple solution here. One thing might be more community education in the Sikh and South Asian community for families who are willing to take in children to say, you can't be paid for this, and are you willing to do it? You're willing to do it, and you cannot be paid, right? Another option would be for more Sikh family members to qualify to become foster parents, and then for working with the city to work with social work organizations to have these be appropriate foster care placement, especially for older teens. The nice thing about parents becoming foster parents is they get paid by the state to become a foster parent. Of course, it takes a long time, takes investigation. Another possible option is foster care. And we have had some teens from Central America who don't want to be in foster care. They want to live and work and earn money to send home to their younger brothers and sisters. But they're starving, or they're living in these horrible households of 9, 10 men all sharing a room in a basement apartment in Queens, and there's plenty of times they don't eat if they don't work. So we've had them meet with social workers, and the social workers explain to them the variety of placements that are available, and they can sign themselves out after they turn 18. And so the kids, often the teens, say, you know what, this isn't so scary. I'm going to take this option. Once you are in the foster care system, you clearly qualify for SIDGE. I mean, assuming your parents have abandoned you. Now, there is one bad case you probably know that came out of the second department in which the child's parents didn't want the child to leave the Punjab, but the boy wanted to go. And the family court judge refused to make the special immigrant juvenile findings, saying your parents didn't abandon you. They opposed you going. I'm not going to find that it's not in your best interest to be reunified with your parents, because it would be in your best interest for you to go home. So the facts of the South Asian cases, I think we have to be even more thoroughly prepared and thoroughly document, and probably bring in more witnesses and bring in more people from the community to testify to the bona fides of the guardian.
Are these children required to be in a school, like, let's say they're post 18 and foster care, so are there requirements for them to be, that's another concern, they don't want to go to school, like, even though I encourage
Up to the age of 18, yes, they're required to go to school, unless they can qualify for an option under state law. And I'm actually not enough of an education expert, but there are adult education options. And the door has an education expert. We actually have a research assistant this summer working on more education resources for us. But, you know, I think just like with any of our immigration clients, we have to say you can't always have everything you want right now. And you're going to make sacrifices by going to study algebra at the public high school, just like the rest of us did, right? And I know they want to earn money, they want to pay off the smuggler, I understand. I do think, though, if you can convince the child to testify against a smuggler, they might qualify for a U visa. But
unfortunately, we have 10 cases right now, and they're all the same pattern. Someone, I was shocked to hear the amount of fees and tried to
Right.
encourage them to do that.
And of course, they want you to be pro bono. Yes.
And like the work I'm doing, and but
Yeah. No.
it's fine.
It's such a complicated story. The Chinese are similar, and the family court in Queens is particularly very cautious here. So I think that it could be. I'm thinking of my own family history. My grandmother came from Russia, lived with an older sister, and she began to work immediately in the family business. That's how she earned her keep. She was barely able to go to school, and I think she dropped out by the 6th grade. And she took care of the children and helped run the business. And that was just the nature of it. And in that era and time, we didn't think that was child abuse. Today, we don't find that acceptable. So it might be meeting with the sponsor, the guardian, and saying he can work part-time after school, and it's going to be slower and longer, and he can contribute to the household, but it has to be appropriate under child labor laws. And, trying to say it's better than not having status or facing a deportation order, right? If you can get them to do the long-term thinking. But I have really worked hard in the trainings I've had with the family court to not punish the child for the situation and to think of alternative remedies for the child. I have heard of some religious organizations who are trying to recruit guardians, people who will be guardians.
I went to the religious leaders and the presidents of the
Right.
gurdwaras, and turned out I found out from the kids, they're just making money because, if they refer someone, the guy's getting 20,000, the president is getting a cut out of it. And so it's, and they told me, they're like, don't even bother going that route, because that's where.
So maybe another route there would be to work with a city council officer and some of the social work agencies in New York to create a culturally appropriate halfway house, a teen halfway house. And I really work with a systemic solution, right? Like we have with sex workers and with other children who've been trafficked. But again, this is not unusual. I got into this field long before the current surge. Kids from Bangladesh, kids from China, kids from Tibet, kids from Burma, different cultural expectations, horrifying to our traditional American 21st century values, but again, not that different from the past of what immigrant families did. Oh, that was such a good question. Yes, sir.
This is really a question, just a comment, that there was a very interesting article in Sunday Times.
Yes, by
If anybody has the Sunday Review,
yeah.
it covers a lot.
It does, and the author of that, well, first of all, Frances Robles wrote a really good piece about the violence in Honduras. And it was interesting to me because the month before she'd interviewed me saying, the kids from Honduras just want to work. And I don't get any credit in the story, but I said, go back and ask more questions, right? But then this is Sonia Nazario, who wrote the book Enrique's Journey, which we always have our students and externs read. And we gather these materials for you as well, so that, again, if you take on a case with us, we'll give you resources from Honduras, El Salvador, Guatemala, Ecuador. Those are the majority of the cases that we are currently seeing. But it is an excellent piece, and I think she's a great voice for compassion for these children. Just to put it in context politically, it's getting difficult when you think of 60,000 children arriving. But when I began practicing immigration law, we got 600,000 asylum applications a year. So most of those were from Central America because of the horrible civil wars in the 1980s. Most of those were denied. Most of those people never left and qualified for the amnesty of '86 or for special legislation we've had since for Central Americans. But our government can handle more than 60,000 applications. I know caring physically for children takes more care, but the reality is that that's still a small number given our country's capacity and our past history. I'm just hoping in an effort to do something to stem the surge of children arriving, we don't step on their due process rights. And we are not yet seeing those cases. We expect this next month and the month after to start seeing kids that were apprehended in April and May, because it does take time for the court to assign them to the immigration court.